Imagine you're driving home just after midnight. The roads are empty, the street lights casting shallow pools of orange across the asphalt. In your rearview mirror, a set of headlights appears. Then the colors, blue and red, slicing through the dark. Your stomach drops. In the next 60 seconds, everything you say and do will be recorded, analyzed, and potentially used to reconstruct a version of events that you might not even recognize. Most people believe they know their rights. They've absorbed legal drama dialogue, they've watched interrogations play out on true crime channels, and they assume that when the moment comes, they'll know exactly how to handle it. But here's the uncomfortable truth. Law enforcement officers in the United States and the United Kingdom are trained with a specific set of psychological tools designed to bypass your awareness. Not to break the law, but to nudge you past the boundaries of your own legal protections without ever raising a hand. They count on one simple, devastating fact. Almost nobody truly understands their own rights when fear floods the brain. There's one question in particular that police hope you'll answer without thinking, a question that has tripped up thousands of people who believed they were being helpful. I'll reveal what that question is later in this video, and once you hear it, you'll realize why they'd prefer you never watched this. But first, let's start at the exact moment everything begins to go wrong. The traffic stop is already a psychological ambush. From the officer's perspective, every encounter starts long before they reach your window. Dispatch has already given them a location, a vehicle description, perhaps a registered owner's name. They've already formed a preliminary mental picture. As they approach, they're not just looking at your license and registration. They're running what's known in training circles as a threat assessment and an evidence scan. They note where your hands are, how quickly you pulled over, the way you're breathing, the clutter in your back seat, the stickers on your bumper, even the way you make eye contact. All of it goes into a rapid, often subconscious risk calculation. And here's where it gets strange. The first words out of their mouth are rarely in order. They're almost always a casual greeting designed to disarm you. "Good evening, do you know why I pulled you over?" That question feels like a formality. It's not. It's an interview prompt disguised as small talk. The moment you open your mouth to speculate, "Was I speeding? Is my taillight out?" You've just volunteered a statement that can be logged and later used to establish that you were aware of some infraction. You've also shifted the dynamic from their burden of proof to your admission. Almost nobody talks about this part. Police training manuals, from the Reed technique used in many American departments to the peace model introduced in the UK, emphasize that a subject's own words are the most powerful evidence an officer can collect. Physical evidence requires labs and chain of custody. Testimony requires corroboration. But a spontaneous utterance, blurted out while your heart is racing, is considered highly reliable in court. That's why the approach feels friendly. Friendliness generates vulnerability. Vulnerability generates speech. Speech becomes evidence. But the reality is completely different from what most people assume. You are under no legal obligation in either the United States or the United Kingdom to answer that question at all. In the US, during a traffic stop, you are temporarily detained under what the Supreme Court calls a Terry stop, based on reasonable suspicion. You must provide your license, registration, and proof of insurance when asked. Beyond that, you can decline to answer questions. In the UK, a stop by police requires that you give your name, date of birth, and address if there is reasonable suspicion of an offense, but you are not required to answer questions about an alleged infraction. Yet very few people stay silent because silence feels rude, uncooperative, or suspicious. And police know that. They rely on your instinct to be polite. Your desire to appear helpful is one of your greatest legal vulnerabilities. Let's pause right there. If you've ever been pulled over and felt that pressure to explain yourself, drop a comment below with just the word guilty, even if you weren't. It's a fascinating glimpse into how social conditioning works. It'll remind us just how many of us would have talked our way into a problem that never needed to exist. Now, let's widen the lens. Traffic stops are just one arena. Consider the everyday street encounter. You're walking through the city center in Manchester, or maybe across a parking lot in Chicago. An officer approaches and says, "Can I have a word?" You stop because you think you have to. The truth is far more nuanced. In the United States, police can initiate a consensual encounter without any level of suspicion. You are not detained. You can ask a single, legally magical question. Am I free to go? If the officer says yes, you can walk away. If they say no, you are now seized under the Fourth Amendment, which means they need reasonable suspicion. The moment you ask that question, you force them to define the nature of the encounter on record, which protects you later. In the UK, the Common Law and the Police and Criminal Evidence Act, known as PACE, also recognize that you do not have to stay and answer questions unless you are under arrest or being lawfully detained for a search. A simple, "Am I being detained?" clarifies the situation immediately. Those 4 words shift the balance of power. Yet police hope you don't know them, because a confused citizen who stands still and answers questions out of anxiety is far easier to investigate than one who calmly asserts boundaries. And then something unexpected happened in recent years. Body-worn cameras and dash cams have made these moments publicly visible in ways they never were before. We can now see exactly how officers phrase their requests to blur the line between a voluntary conversation and a compulsory interrogation. One technique, widely documented in both American and British policing research, is the embedded assumption. Instead of asking, "May I search your vehicle?" they'll say, "You don't mind if I take a quick look inside, do you?" The phrasing is deliberate. It frames refusal as a breach of social cooperation. It also sidesteps the requirement to inform you that you can decline. In the US, the Fourth Amendment protects you from warrantless searches, but consent is a powerful exception. If you say yes or even passively nod, you've just waived a fundamental right. In the UK, officers have extensive stop and search powers under PACE and other statutes, but they still sometimes ask for consent when the legal threshold for a mandatory search might not be clearly met. If you give consent, you lose the ability to challenge the legality of that search later. The single most powerful phrase you can utter in that moment is, "I do not consent to any searches." It's one of those short, film-ready lines you'll hear again later. It is not uncooperative. It is a legal shield. And that brings us back to the open loop I mentioned at the beginning. Remember the question police hope you'll answer without thinking? It isn't always, "Do you know why I pulled you over?" That one is famously dangerous. But there's another, far more subtle variant that appears in both street encounters and traffic stops. After establishing some rapport, an officer might lean in and ask, "Is there anything in the car I should know about?" On the surface, it sounds considerate, almost protective, but legally, it's a vacuum designed to suck in incriminating statements. If you say, "Just a pocket knife I use for work," they now have justification to explore further. If you say, "Nothing," and they later find an old, forgotten pocket knife that violates a city ordinance, that statement can be used to demonstrate deception. The safest response is polite, non-evasive, and firm. "I have nothing to declare and I do not consent to searches." That statement is not an admission of guilt. It is an exercise of your right to silence, a principle embedded in the Fifth Amendment in the US and in the common law right against self-incrimination in the UK, despite the adverse inference provisions we'll get to in a moment. Silence is not an admission of guilt. That's another one of those lines you'll want to remember. This changes everything when you understand how interrogation works. Police training, from the Reed Technique's 9-step process in America to the conversation management approach used in British advanced interview training, teaches officers to create a sense of inevitability. The goal is to make you feel that silence is futile and cooperation is the only path to leniency. They may say things like, "I just need your side of the story to clear this up." But here's the razor edge of that statement. In the US, police can legally lie to you during questioning. They can claim to have evidence they don't possess. They can say a witness identified you when no such witness exists. They can minimize the severity of the offense. "This is just a minor thing. Help me understand." In the UK, officers are bound by tighter ethical guidelines under PACE, and outright deception during a formal interview would likely render the interview inadmissible. But they can still use tactical questioning and suggestive language during the preliminary stages. The intention is the same worldwide: get you talking. Because once you start, the psychological momentum is almost impossible to stop. Take a real-world example that's played out across countless dashcam videos. A driver is stopped for a burned-out license plate light. The officer asks, "Where are you headed tonight?" The driver, wanting to be normal, says, "Just coming from a friend's barbecue. Had a couple beers, but I'm fine." That sentence, "a couple beers," is now a free-floating admission of alcohol consumption. It shifts the officer's suspicion from a routine equipment violation to a possible DUI investigation. They'll then ask, "How many is a couple?" and the spiral begins. The driver thinks they're being conversational. The officer is building probable cause. The same mechanism is at work in the UK. An officer stopping a pedestrian might ask, "Have you had anything to drink tonight?" A truthful, "Just a pint," immediately opens the door to a breathalyzer or a more invasive stop. In both systems, the common factor is that we are conditioned to answer authority figures when they ask a direct question. Police rely on that conditioning the way a magician relies on misdirection. So let's slow down and address the biggest elephant in the room. What about the right to silence? Isn't it true that in the UK your silence can be used against you? The answer is yes, but with crucial context. Under Section 34 of the Criminal Justice and Public Order Act 1994, if you fail to mention a fact that you later rely on in your defense, and it was reasonable to have mentioned it at the time of questioning, an adverse inference may be drawn. This is often summarized in the UK caution. You do not have to say anything, but it may harm your defense if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. That caution is designed to be intimidating. It sounds like a trap. But what police hope you don't fully appreciate is that this caution only has force if you have something later to rely on. If you have not been arrested and you are merely being questioned as a potential witness or in a stop-and-search scenario, the caution often hasn't even been given yet. The safest course is still to say nothing beyond your basic identifying details, and to state clearly, "I wish to speak with a solicitor before answering any questions." In the US, the Miranda warning is similar, but the right is stronger in one critical way. Once you invoke your right to remain silent post-arrest, interrogation must cease. If it doesn't, any subsequent statement is presumed coerced and inadmissible. But the trick is that many people waive this right without even realizing it. They nod, they murmur, "I understand," and then they keep talking. The waiver must be knowing and voluntary, but police are trained to make it feel like a bureaucratic preamble instead of a profound legal threshold. So you have to speak your invocation unambiguously. "I am invoking my right to remain silent," or "I want a lawyer," are phrases that demand immediate cessation. A mumbled, "I think maybe I shouldn't talk," might not be enough. And this is where the clip-worthy lines really start to crystallize. Every conversation is evidence. That's 5 words you should mentally tattoo onto any encounter. You are being tested before you even know it. That's 6 words. These are not paranoid statements. They are informed recognitions of how the system functions. Because the most dangerous word you can say to an officer, the one that has undone more legal protections than perhaps any other, is simply this: sure. When you're asked, "Do you mind if I search your bag?" and you reply with "sure," you've just granted legally valid consent. You might have meant to say, "No, I do mind," but the casual affirmation slipped out. Police are taught to ask for consent in a way that elicits exactly that kind of informal, unguarded response. They'll nod along as if it's no big deal. But the moment you agree, the entire legal landscape changes. You can withdraw consent at any time. That is another piece of information police rarely volunteer. If you initially say "sure," but then gather your thoughts and say, "Actually, I've changed my mind. I do not consent to further search," they are legally required to stop, assuming they have no other legal basis to continue. But that window of awareness rarely opens because most people never realize they can revoke consent once it's given. Let's raise the stakes even higher. What about the interaction at your own front door? This is an area where almost everyone makes the same mistake. In the US, the Fourth Amendment protects your home with the highest level of privacy. Without a warrant, exigent circumstances, or valid consent, police cannot enter. But they can knock. And when you open the door, they'll often ask, "Can we come in and talk for a moment?" The default human impulse is to step aside and welcome them, because refusing feels like an admission of guilt. This is the doorstep interview tactic. By inviting them in, you've just transformed a constitutionally protected private space into a consensual investigative arena. Everything they see in plain view after stepping across the threshold is now fair game. If they smell something, if they see something, the encounter escalates. The better practice, legally speaking, is to step outside, close the door behind you, and say, I'm happy to talk right here. What's this about? That small act maintains the boundary. In the UK, similar principles apply under PACE. Unless they have a warrant or the power to enter without one under a specific statute, they can only enter with consent. Yet how many people have simply let them in because they sounded polite? Probably too many. Halfway through this journey, I want to pause for an honest reflection. This information can feel unsettling. It can feel like we're framing police as the opposition. But that's not the intent. The vast majority of law enforcement officers are doing a difficult job under immense pressure. The problem is system design, not individual morality. The system is structured in such a way that your ignorance of your rights benefits the efficiency of investigations. It's not a conspiracy. It's a feature of how adversarial legal systems have evolved alongside investigative training. Knowing your rights doesn't mean you're anti-police. It means you're pro-civil society. If you're finding this eye-opening, hitting the like button is one of the most effective ways to push this conversation into the feeds of people who might desperately need it before their next encounter. No one plans to be stopped. Now, let's add a layer that most videos skip entirely: the psychological phenomenon known as acquiescence coercion. Research conducted in both American university labs and UK-based legal psychology centers has demonstrated that when an authority figure presents a request in a permissive tone, "Would you mind stepping out of the vehicle?" subjects experience a measurable drop in cognitive resistance. The brain interprets the phrasing as a cooperative probe rather than a command, which weakens the natural instinct to self-protect. But the legal effect is identical to a direct order if you comply. And even more disturbing is the finding that after a person agrees to one small request, the likelihood of agreeing to a much larger one increases dramatically. It's called the foot-in-the-door technique, and interrogation training exploits it mercilessly. First, they ask you to roll down your window all the way. Then they ask you to turn off the engine. Then they ask you to step out. Each small yes builds a momentum of compliance that becomes very hard to break. The counter strategy is simple but psychologically demanding. You must remain polite but separate compliance from legal obligation. You can ask, "Am I required to do that, or are you asking me?" This question pulls the legal framework back into the open. If they say you're required, they must have a legal basis. If they say it's just a request, you can decline without escalating the situation. This takes us to perhaps the most misunderstood concept of all: the right to film. In both the US and the UK, you have a generally recognized right to record police officers performing their duties in public, as long as you do not physically interfere. In the US, multiple circuit courts have upheld this under the First Amendment. In the UK, there is no statute prohibiting the recording of police, and the College of Policing guidelines affirm that officers should not prevent a member of the public from filming unless there are genuine operational security concerns. Yet across thousands of body cam encounters, we see officers telling citizens to stop recording. Some claim it's an officer safety issue. Others say it's a privacy violation. Almost always, they're wrong. The knowledge that you can calmly state, "I am legally recording this encounter for my protection and I am not interfering," can completely alter the tone of an interaction. Police hope you don't know that, because a recording is the most reliable witness you can ever have. It's an evidence multiplier that eliminates the "your word against mine" dynamic. And now everyone carries a camera in their pocket. But what if you don't? What if it's just you, an officer, and an empty street? This is where the open loop from earlier resolves. The question they hope you'll answer, the one that functions as a master key for further investigation, is not just a trick, it's a pressure point, and it can be diffused with a single, unassailable phrase. After you've provided your required identification, after you've confirmed whether you're free to leave or being detained, you can say the following: "I don't answer questions without a lawyer present." In the United States, that statement is a clear, unambiguous invocation of your Sixth Amendment and Miranda rights. It requires all questioning to stop immediately. In the United Kingdom, you have the right to free and independent legal advice in the police station, and while you don't have the right to have a solicitor physically present during a street stop, you can still state that you will not answer questions without legal advice. This might not compel them to halt all questions, but it establishes that your silence is on legal grounds, making it much harder to argue later that your silence implied deception. That's the reveal. The question they ask, whether it's, "Do you know why I pulled you over?" or "Is there anything you want to tell me?" Or, "Can I search you?" All of those are neutralized by the same activated right. And police training doesn't teach them to celebrate that invocation, it teaches them to work around it. So when you invoke it clearly, you have stepped out of the script they rehearsed. Let that sink in. The entire encounter is a script. Police have practiced their opening lines, their conversational segues, their empathic reflections. But your role in that script is not fixed. You can choose a different dialogue. You can be respectful but silent. You can be cooperative with the law without cooperating with your own potential conviction. And the law protects you in that choice. This is not a loophole. This is the intentional architecture of rights designed centuries ago to prevent the state from forcing confessions. Silence is not an admission of guilt. Every conversation is evidence. You are being tested before you even know it. Those sentences are not taglines. They are survival tools for a moment that might never come. But if it does, you will have already made the decision before fear has a chance to decide for you. Before we land this, I want to give you two more phrases that are worth their weight in legal gold. The first, "I do not consent to this detention." If you believe you are being held without reasonable grounds, state that clearly and calmly. It doesn't automatically end the detention, but it frames the encounter as contested from the start, which is invaluable in any subsequent legal challenge. The second, "Am I free to leave now?" Repeat it as often as needed. The answer changes the legal nature of the entire interaction, and you have every right to ask. Those are lines so tight they could become shorts on their own. "I do not consent to this detention." "Am I free to leave now?" "I don't answer questions without a lawyer." Clip them, remember them, share them. Let's widen our view to the aftermath. Many people ask, won't the police just arrest me if I assert my rights? That's a natural fear. But in both the US and the UK, an arrest made solely in retaliation for exercising constitutional or convention rights is unlawful and opens the door to serious civil liability and evidence exclusion. That doesn't mean it never happens. It does mean that the law, in its purest form, is on your side. The more you know, the safer you are, because you can document the event afterward precisely and file a complaint if needed. Knowledge compounds when you have to recount what occurred. Now, as we move toward the end, I want to circle back to the psychological state you started with. Imagine that same midnight traffic stop. The lights are in your mirror, your heart is racing. But this time, instead of panic, you feel a slow, deliberate clarity. You pull over safely. You place your hands on the steering wheel. When the officer approaches and asks, "Do you know why I stopped you?" you respond politely. "I'm not going to answer any questions without a lawyer present, officer. Here's my license and registration." When they ask you to step out, you ask, "Am I required to?" When they ask to search, you say, "I do not consent to any searches." All of this delivered calmly, with respect, but without yielding a single unnecessary syllable. The outcome is unknowable, but one thing is certain. You haven't handed them the words that could dismantle your future. You haven't built their case for them. You've done what citizens in a free society are meant to do. You've held the line. That is the real message behind the title you clicked. What police hope you don't know about your rights isn't a secret playbook. It's the simple truth that rights are only real when they're used. They cannot protect you from inside a drawer. They activate only in your voice, in your silence, in your considered refusal to gamble your freedom on a few friendly-sounding questions. The most important thing you can do right now is share this with someone you care about. Send them the link. Start a conversation over coffee, because the information becomes far more powerful once it leaves the screen and enters the real world. Thank you for spending this time here. If this video has shifted something in the way you think, drop a comment below with the phrase, "I know my rights," and tell me one specific strategy you learned today that you never considered before. I'll be reading through them, and I genuinely look forward to hearing your stories. Until next time, stay informed, stay calm, and hold your ground.